Hello, this is BA 487 International Business Law. This is topic 1, video number 1, and we're going to do a brief introduction to international law. And we'll be utilizing the PowerPoints under topic 1 on our Moodle page for the video. Okay, so I want to start with more of a theoretical discussion about what do we mean when we say law. This is, of course, an international law, but I want to step back and just talk about law in general. When we use the word law, what do we mean by that? When you think of a law, you think of something like the speed limit that I've got posted here on this slide, 55 miles per hour. And that's one of the most common laws that we deal with on our daily lives, speed limits and traffic laws and other similar types of laws. And it seems very simple when we say, okay, what is law? Well, in your everyday world, you probably think, well, a law is some kind of a rule that is created by a governing body, like a speed limit. And you think of, generally speaking, when we talk about law, that if you violate the rule, there is some enforcement mechanism, such as the police officer pulling you over for a speeding ticket, and then going to court if you want to fight the ticket, and then ultimately a judge would issue a penalty, such as a fine, or if it was criminal, jail time, or some other penalty for violating the law. So that's sort of the standard paradigm that we think about when we think of, okay, what do we mean by law just in general? Well, what I've described is really what we would call domestic law. And one of the first basic concepts to break things down is domestic law versus international law. Domestic law, when I use that phrase, I'm referring to the law of the internal law of a country, the internal law of a state. And so typically we think of law as being primarily created through constitutional law, like the United States Constitution, or what we call legislated law, which is law that is created by a legislative body within a government. Those are usually known as statutes, which are laws created by a legislature. So in the United States, for example, we have federal law, which is the United States Code, which is statutory law that's written by Congress. Every state also within the state of the United States has its own legislature that can create state law. And those are written rules that we're familiar with. We also have what are known as administrative rules, which are laws that are created by administrative agencies, such as Fish and Wildlife for fishing and hunting regulations, health department rules for restaurants, other types of administrative rules that apply to farms and dairies, those kind of rules and regulations, which are created by administrative agencies, such as the Environmental Protection Agency, etc. So for the most part, when we talk about and think about law, we're in our minds thinking about legislated law. That is law that has been created by a legislative body. So let's start with that word legislated. The term legislate means to be able to create law, to write law, to make law. And that's one of the fundamental powers of a government, to be able to make law. So here in the United States, of course, we have Congress at the federal level. Every state has a legislature. Cities and counties all have the ability to create law through a legislative type process. Well, I want to step back for a minute, because when we talk about international law, it's fundamentally different. And that is, when we talk about international law, we really don't have a world legislature. International law is law that is essentially the law that relates to how sovereigns interact with each other. And we'll talk about the sovereignty more in a few minutes. But it is fundamentally different than domestic law in many ways. Now, a lot of that's changing, and that'll be one of the themes of the course throughout the term, is historically, how has international law making changed over time? Historically, how is it made versus modern rules of international law? And we'll get into that more later on. But for right now, I just want you to start with the concept that we really don't have an international law legislative mechanism like we do within domestic law. Along with that, we really don't have an international enforcement mechanism to the same extent that we do domestically. We don't really have an international police force, international systems like that. Now, you may say, well, wait a minute, what about the United Nations? Well, the United Nations sort of has that, but it's not a true legislature, and it doesn't truly have police power to the same extent that we think about within domestic law. And we'll get into the nuances and that more when we talk about the United Nations later in the term. But for right now, I just want to start off with this basic kind of idea of what is law, how is law created, and how is domestic law different from international law. So when we say law, again, we think of a speed limit as being a law for which there is a penalty. So here's a definition within the United States. Law refers to any rule that subjects a party to potential criminal or civil penalties in the event that they violate the rule, the law. Well, law is actually bigger than that, in my estimation at least, and this is especially true for international law, because in the international realm, since we don't really have the same type of domestic enforcement and executive branch, judicial branch type, and legislative branch, we really don't have the same type of enforcement mechanisms. And that's one of the fundamental issues about international law. Is it truly law in the same respect that we apply to domestic law? Well, again, let's step back one step farther. What is law to begin with? Does it really require a written rule? Are there unwritten rules? Are there laws that are created outside of mankind? So let's go to the next slide. This is a picture of a shark on a coral reef. And you may be thinking, okay, what in the world does this have to do with international law or law at all? And the question I would ask is there law on a coral reef? I mean, we have a shark, which is the large fish. We have another fish, which is a little bit smaller, well, quite a bit smaller, but still pretty big. And then we have a whole bunch of smaller fish. And then down within the coral, we've got crabs and shrimp, etc. And so if I asked you, is there law on a coral reef? Well, what is law to begin with? Well, law is basically a way of behaving that if you violate the law, there is a consequence. That's one way of looking at it. And so on a coral reef, in a sense, there is a form of law that's going on, which we would sometimes refer to as the law of nature or natural law. And that is essentially the idea that law can be created through natural consequences. So on a coral reef, for example, a small fish swims out of its cave or gets out in open water where it can be eaten by a large fish. In a sense, that's a form of natural law. Even though it's not a written rule, we don't have the Congress of the fish where they're writing rules that apply to fish and crabs and shrimp. It's unwritten natural law. That is the law of natural consequences. And again, you may be thinking to yourself, well, what does this have to do with international law? Well, what we're going to see as we work our way through this term is that in some respects, international law is similar to the law on a coral reef, that is natural law. And especially when we look historically at how international law was made. Historically, of course, like the coral reef, we had states that have lots of power, either militarily or economically. For example, the Roman Empire. And historically, international law essentially was created through conquest or military or economic power. That is, the stronger would write the laws and override or impose those laws through military or economic power on the smaller. So the Romans would go out and conquer a territory, and they would impose Roman law upon that territory. Similar to a coral reef, where essentially a shark, in a way, is writing the law by being able to eat a smaller fish. Now, we sometimes refer to this idea of law that's created through power as rule of force. And this is going to be a common theme throughout the term, what we call rule of force versus rule of law. And we'll talk more about that later, but basically it means that rule of force is law or rules are created through power, be it military, economic, or otherwise. The opposite of that, to a degree, is what we call rule of law. And that is the idea that law and institutions such as courts, legislative bodies, and other legally structured systems, rather than pure power, should be the creator and the enforcer of law. So to make, again, a comparison to a shark on a reef, rule of force would be the shark eats the smaller fish, and there's not much the smaller fish can do about it. Rule of law would be each fish has their own rights and has the ability to write rules that govern or limit the power of the stronger, in this case, the shark. So we have the same kind of idea internationally. We have larger countries and smaller countries. Larger countries may have more military or economic power, and historically they impose their will without recourse. Whereas in modern international law, its rule of law is the primary idea. That is, the smaller fish, or all the fish, including the larger, write rules that they all agree to abide by. So essentially, law is created on a coral reef through natural consequences. If you're a small fish and you don't follow through and stay in your hiding spot, you may be eaten. The consequence, of course, in that case would be you're no longer around. But there's another way that law, in a sense, is created, and that is through natural law, like the coral reef, through mutual consent. So let's go to my next slide here. And again, we're on the coral reef. So here I have a picture of a fish and a shrimp. The fish is what's called a grouper. In this case, it's a blue spot grouper. And the shrimp is in the fish's mouth. Not because the fish is eating it. This type of shrimp is called a cleaner shrimp. And there's an interesting thing that takes place on a coral reef. The cleaner shrimp will sit on a piece of coral, and larger fish will go to the small little shrimp. The fish will open its mouth, and the shrimp will go into the mouth at its great risk, of course, because it may be eaten. And while it's in the mouth of the fish, the shrimp will pick out little parasites out of the mouth and gills of the fish. The fish does not eat the shrimp. When the shrimp is done, the fish leaves and the next fish comes in, and the shrimp will clean that fish. And so there's unwritten law that is essentially being created. This is the law of mutual benefit. Mutual symbiosis is what they call it in biology. And in a sense, it's a form of a law in that the fish does not eat the smaller shrimp. The fish benefits by allowing the shrimp to eat the parasites. And the shrimp benefits, one, of course, by not being eaten, but also by getting a relatively easy meal. And, over time, biologically, this has developed into the form of a biological or natural law. Now, again, what does this have to do with international law? Well, historically, and also in current modern international law, we see the same type of idea. That is, even though a larger country, such as the fish, could easily swallow the shrimp, many times international law is created through treaties, organizations such as the United Nations, the World Trade Organization, European Union. And the idea is the fish and the shrimp agree to work together because it's mutually beneficial. Even though theoretically the larger country could overtake the smaller country, the fish could eat the shrimp, through mutual benefit, they have agreed through conduct or words or written treaties or whatever that they will engage in this mutually beneficial behavior. And we see quite a bit of that in international law, both historically over time, in that the sovereigns of whatever country or nation or area it may be a king or a queen or a warlord or a chieftain, whatever the case may be, they agree not to attack each other. They agree to trade their merchants with each other. They agree not to take hostages. They agree to other types of activities because it's mutually beneficial. Let's say I have a country and I want my merchants to be able to trade with your merchants in your country, and we agree not to attack each other and not to rob the merchants or steal their goods, and to protect them when they're within our own boundaries because it's mutually beneficial for trade. So this is a form of natural law, unwritten law, law of the coral reef, law of the jungle, whatever you want to call it. So in some respect, these two slides, the shark representing law created through power, and the fish and the shrimp, that is law that's created through mutual benefit. We're going to see these two themes recurring over and over, both historically and in modern international law throughout the term. So, what is law? Law is clearly written rules created by legislative bodies domestically. They may be unwritten rules through conduct or ways of activity, such as natural law that we've just discussed. Those all have in common the same basic idea that there is some sort of behavior or action. Sometimes we call that a norm, like normal, normative. A norm is a phrase we'll be using off and on throughout the term. A norm is a way of behaving. And so sometimes we'll see written law, unwritten law, natural law as law. But I also want to differentiate between law, that is a rule that has legally binding authority, some sort of consequence that is viewed as having legal consequence, as opposed to other types of rules such as courtesy, which we sometimes refer to as comity right here, courtesy or comity. We also have traditions, cultural, sociological norms and behaviors that may or may not actually constitute a law. So let me give you an example. Over here I've got shaking hand symbol. So common practice in the United States, when somebody greets another person, it's pretty common to shake their hand, although that's changing now with COVID-19, of course. But nevertheless, we'll use that as an example. So you meet somebody and it's common social practice to shake their hand or greet them in some way. So before COVID-19, let's just say I meet somebody and I refuse to shake their hand. Now, have I broken a law? Well, it's unwritten. I mean, there's no written law that says you have to shake somebody's hand, at least none I'm aware of, but it's common social practice. I guess another comparison would be if I'm walking down a crowded hallway. In the United States, at least, we tend to walk on the right side, just like we drive on the right side. And so the idea, if you're walking down a hallway and it's crowded and you're walking on the left side, you're going to disrupt traffic. Is that a law or is that a social practice? Is that courtesy? So we see this a lot in international law, where there may be traditions or other types of practices that may not rise to the level of being law, but are more on the level of being good courtesy or whatever you want to phrase. And sometimes it's difficult to differentiate between the two. And of course, that will vary from one country to the next, depending on their internal cultures. In some countries, it may be an insult to shake hands versus another country where it's considered good practice. So that's another issue, that international law deviates sometimes from domestic law, and in that you have different cultures around the world. We also have different legal systems that differentiate based on how their laws are created. And we have to take all that into account when we're looking at international law versus domestic law. Now, traditionally, when we talk about international law, we're talking about law that involves how states interact with each other, versus domestic law, which is the law that deals with the internal going-ons of a country within its own borders. So that's going to be the big differentiation we'll be using throughout this course. Now, with that said, does law require an enforcement mechanism? What if there is no enforcement mechanism? In other words, let's say a large country enters into a treaty with a smaller country. The large country later on does not follow the treaty, violates the treaty. Now, if it was domestic law, you could call the police or you could file a lawsuit. But what about internationally? What avenue or enforcement does the small country have against the large country? Well, historically, you had military might, but if you're a small country without much military power or not much economic power or other type of power, maybe friends in other countries that are willing to help you out, you really didn't have any way to enforce the treaty. And it really came down to rule of force. Unless there was mutual benefit where the larger country was mutually benefiting, then they would follow the treaty anyway. So one of the questions that we look at, can you still have a rule that's considered a law if there's no enforcement mechanism? And the answer to that is yes and no. And that's one of the dilemmas of international law versus domestic law, is we don't have those same kind of enforcement mechanisms structurally, or even in the real world, like you have in domestic. And there's some reasons for that. One of them has to do with sovereignty, which we'll get to in a minute. Another topic, if you do have a law but it's not enforced, is it still a law? Like a speed limit, 55 miles per hour. Now that's obviously still enforced, but really if you go out on the interstate, right on I-5, in a 55-mile-an-hour zone, it's pretty rare to see somebody actually consistently driving 55. Most people tend to go above the speed limit a little bit. Not always. And it's, you might drive by a police officer going 58 miles per hour and they don't pull you over. Well, yes, you're violating that written rule, but they're not enforcing it. Is it still a law? Well, yeah, clearly, 55 mile per hour speed limit is still a law. It could be enforced, but in that case, the police officer decided not to for various reasons. Now, think about that internationally. What if we have treaties, but those treaties are never enforced? Do those treaties still have power? Are they still considered a law? And that's one of the dilemmas of international law versus domestic law, is we don't have that clear-cut enforcement mechanism. Now, we'll be talking about historically how that's changed over the years, where we have, over time, through various organizations and treaty making, more and more enforcement mechanisms which are similar to what we see in domestic law. But nevertheless, it's still a major difference between domestic versus international law in how it is enforced, or it may not even be enforced at all because the only way to enforce it is through military use or military force or economic sanctions or other type of economic force. And we'll talk more about that as the term progresses. Okay, this next slide again, just some basic introduction to international law. is the concept of what is a state. So when I use that word state here in the United States of America, we think of Oregon, California, New York, Florida, whatever, right? Those are all states. But it's different internationally. On an international level, the state of Oregon would not be considered a sovereign state. The state of Oregon, Idaho, Florida, et cetera, those are all lower level political entities. In international law, when we use the phrase state, we mean the political entity on an international level that has control over the geographical area, the highest level of government in that geographical area. So in the United States of America, the international state would be the United States federal government. We are a federal system. So the federal government, representing all 50 states of the Union, is considered the international state. So sometimes it gets a little confusing because I'll be using the word state, and when I use that word, that term here in international law, I'm referring to the international sovereign, not a subunit of the government like a state or a province or other type of lower level county, city political unit, okay? So a state in international law is different. I've got a typo there, I'll fix that. Is different from a state in domestic law. The term state refers to federal or other type of government that has legal recognition as a sovereign for international purposes, not a subunit of a government like the state of Oregon. Okay, that leads us to this next slide. The sovereign state concept in international law. So when we talk about sovereign state, what we mean by that is the power that's held by the governing entity within a geographical area that has control. And when we say a sovereign state, the term sovereign means that no other power, be it military, economic, political, social, whatever power you want to talk about, no other power has higher authority within that area. So the term sovereignty has massive legal significance in international law. It really is the fundamental basis of international law. The idea that sovereigns have their own power and don't have to really answer to anyone else unless they want to. They are the masters of their domain, so to speak. Now, historically, of course, when we talk about sovereigns, we're talking about, we're going back hundreds and even thousands of years to warlords, tribal chieftains. We're talking about kings, queens, and other royalty, dukes, whatever unit it was, and essentially a city-state like Venice, etc., princedoms and fiefdoms. And so essentially we had international sovereigns. You may have two kings right next to each other controlling an area the size of maybe the Willamette Valley. And they each had enough military power to protect their own area. They were considered a sovereign state, primarily through the ability to defend themselves militarily and economically. So the concept of a sovereign is that no other power has authority over that area. Now, what that means internationally has changed over the years, but primarily, when you think about international law, if I'm a sovereign, let's say I'm a warlord or a king or whatever of my area, why would I ever agree to limit my power? Why would, unless I was forced to, like by the Roman Empire? So the term sovereignty means that you have the power over your own domain. Now, when it comes to international law, one of the fundamental concepts of international law is the idea that, unlike domestic law, where there is power of the government over the people through legislature, police, the court system, in international law, the sovereign has absolute power within their domain. And so if you think about international law, when you have sovereigns agreeing with each other, in essence, they're limiting their power. They are consenting to be governed by international law. You know, in a sense, if you think about law, it's really a limitation on power, right? And so international law essentially requires the consent, the agreement, either expressly like through a treaty, like a contract, or through natural law to be governed or behave in a certain way. That's one of the fundamental concepts. So let me just kind of explain a little bit about what I mean. So like here's a map of Italy, what we now know as Italy, from 1494. At that time, the area that is now Italy was divided up into what we would call city-states. So we had Florence, the Republic of Florence, which governed by the city of Florence, Venice, Naples down here, the Papal States governed in Rome, of course, the Republic of Siena, the Duke of Milan. So each of these were separate sovereigns. And when we talk about international law, at that time, essentially international law referred to how they would interact with each other. So the Republic of Venice and the Duke of Milan, they may agree not to attack each other. They may also agree to defend each other if one of them is attacked by another foreign power. They may agree to exchange ambassadors. That is international law historically and how it was made. It was made through the agreement of the sovereigns. Now that has changed over time, and as we'll get into more later on in the term, now we see international law being made more often through organizations such as the United Nations, etc. But just historically, that's where we get this idea of sovereign international law being the law that deals with how states interact with each other. Okay, here's another picture. This is of Germany back in 1796. And I want to show you this because I want you to have this fundamental idea that when we talk about international law, we're talking about the law, either natural law of consequences or mutual benefit, or international law created through military or economic power. Changes constantly. It has historically changed constantly because the sovereigns changed constantly as well. And that's true today as well. We have a change of power through elections. We have different countries forming. We have countries that go away. We have countries that split up like the Soviet Union. We have decolonialization and independence. And so we have this constant evolution in the world of countries forming and unforming. Again, international law being the law of how states interact with each other, that too changes over time. So this little YouTube video that just shows the evolution of Germany over time. Let's see if I can get this to work here. Now, I just want you to watch how we have all of these states coming into existence, and then they go away. And then we have larger empires and kingdoms, and it changes over time. So just think if there are treaties between these small sovereigns, when they're overtaken or they change, those treaties basically go away, and you start all over again with international law. And so in essence, international law is a constantly evolving system. And where you may have a new governing body within an area that no longer follows the previous treaties or agreements that were made. And also you have other countries having to react to changes and how they will relate to the new regime or changes within an area. And that's true both historically and in modern international law. Up through World War II, and then post-World War II into the Cold War, up through essentially what we now know as modern-day Germany. So I'm going to pause that. Okay, so I showed you that just to give you, I want you just to have kind of this in the back of your mind, this idea that historically international law changed constantly, and we have these different city-states, different powers. And oftentimes that was due to military and economic power. And back to the idea of rule of force, the shark was essentially use of military and economic power to dominate the smaller countries, to take over, to conquest. Versus now the trend is rule of law, and that is instituting legal systems such as the United Nations to help assist in creating international law, and also to assist in the enforcement mechanisms of international law once they are made. So to conclude on this video, is international law really law? In the sense, yes and no. It's not like domestic law in many ways, because we don't have an international legislature, which we'll talk more about later. We don't really have international domestic type enforcement mechanisms, although that's changing a little bit as well. But we also have the law of natural consequences and mutual benefit. So yes, international law is law to a degree, but it's not the same as domestic law. And then, of course, we have the enforcement issue and the idea of international police versus domestic. And we'll be talking about how historically international law was enforced, or not enforced for that matter, and then how over time that's been changing. And even now today, we still oftentimes have international law that is not enforced at all. And that's often due to both economic and political reasons, as well as military. And we'll talk more about that as the term progresses. So this is the end of topic 1, video 1.